everyone. My name is Jeanna Cooper. I am a collaboratively trained attorney in Greensboro, North Carolina.
And my name's Emily Carico. I'm also a collaboratively trained attorney, also in Greensboro, North Carolina.
You can hold the mic.
No.
I feel like I was just looking at
like a news
um, collaborative law is sort of up and coming. It was really popular on the West Coast, and it's made its way over to the East Coast. Specifically in North Carolina, we've seen it very popular in Mecklenburg County, which is Charlotte, and gaining popularity in Raleigh, but not so much the Triad, and that's where we are.
Yeah, so collaborative is kind of a different experience than I think what a lot of people expect from specifically their family law cases. You can use collaborative law. It's just a method of resolving a dispute. So you can use it in other areas of law. Like it's been used in some state administration. It's now been approved in North Carolina to be used in some business litigation cases as an alternative to litigation. But it is just a method of resolving a dispute, right? So Jeanna and I specifically practice family law. And that's where we've seen the most traction in North Carolina with collaborative is through family law disputes. So today, because of our expertise in family law and knowledge in family law, we're here to kind of talk about the collaborative experience specifically as it relates to those family law issues and to specifically address some frequently asked questions that we get in consultations for folks that are considering the process.
So I think when people come into our office for a consultation, at this point, at least Emily and I at Camino, and honestly our other attorneys as well, want to evaluate their case for collaborative. Not every case is perfect for collaborative, but a lot of them are. And that kind of leads us to a very I won't even say a frequently asked question, more just a comment I see a lot when people come in for a consultation. A lot of people say, oh, he or she isn't going to agree to anything. They come in with this notion that when they get to the point of hiring a lawyer, they're going to court and they're going to fight.
Yeah, and so I guess we should probably talk a little bit more about like what collaborative is. Like when we say collaborative law, what does that mean? So I think most people, at least if you've watched like Law and Order, any kind of crime thing, Lincoln Lawyer, anything with a courtroom, you kind of have an idea what litigation looks like, right? There's a judge usually sitting up on a big dais. There's a couple of tables. There's some really angry attorneys, and they're hooting and hollering and shouting at each other, that kind of thing. What collaborative law looks like is very different. It usually looks like a big round table, and it looks like both parties, so husband and wife, the two spouses, sitting there with their two attorneys, working together to try to figure out all of the different issues that come out of a divorce. So child custody, support payments, property, how you're going to divide everything, how you're going to pay debts, those kinds of things, working together to come to a solution that works for everyone instead of fighting in the courtroom for what may work for one person versus another. So that's kind of a different thing that I think a lot of people imagine, especially with divorces. I think they imagine it to be this like horrible fight. Everyone has a bad story that they know with someone in their life who's gone through this like really horrendous family law case. And most of those are coming out of litigation.
So our little slogan for collaborative is to divorce with less mess, or divorce with less mess. And that's because litigation creates a whole lot of mess, a whole lot of attorney's fees, which is something we're going to talk a lot about, is the financial benefits of doing a collaborative divorce, but a lot of stress, a lot of deadlines, a lot of things you got to file, a lot of paper. But when people come in and they say he or she, they're not going to agree to anything, you would be surprised how many people, once the tensions have dropped and the initial shock of being separated goes away, just want to agree and put it behind them. A lot of people come in and they are just pounding their fists down saying, I want my day in court. Honestly, it takes a few weeks, sometimes longer, for people to come down from the shock, from the emotional turmoil of being separated, and realize that they don't want to fight. They just want to be done. I hear that so often from clients. When is this going to be done? I want this to be over. I've litigated cases that are years old. I know Emily has as well, and it's a hard question to answer. But if you want something done quickly, litigation is not the way that you want to go. We can't control a lot of aspects of the court system, and honestly, it just takes forever.
Yeah, that's totally true. And I think part of what's difficult in family law is there's a ton of emotions that are going on. You're going through the dissolution of your marriage, and that's hard. And the circumstances under which that's happening could be really terrible. Infidelity, substance and mental health issues that come in the middle of a marriage, just the sometimes just the falling out of love of someone. And all of those things can be really emotional and really painful. And ultimately, what you're doing in most, with the exception of child custody, most of a family law case is dealing with finances, dealing with property, dealing with incomes and that sort of thing, revenue from the marriage. And so, what you find is once those emotions have kind of quelled a little and kind of, gone back to maybe their more steady state, people realize that the rest of the case is a financial decision. And part of like what we're talking about, what Jeanna is saying about the timing of things, getting into court, all of that translates to more money. The more time a case takes, the more it's going to cost. And litigation can take years. It is ultimately, even though it's family law and it's families, it is ultimately bound by the same rules of civil procedure. So there are just timelines that have to happen, and you can't make them go any faster than they are supposed to happen, and that can lead to significant delays in cases.
A collaborative divorce is much more predictable than litigation, and this, it's the same. This all circles back to the same. He's not going to agree, or she's not going to agree. They will probably want to agree when they realize how long and how costly it's going to be. But with collaborative divorce, you have very specific metrics, and so it's much more predictable. You have specific, not deadlines, but the collaborative attorneys get together to create some sort of schedule for the case. So okay, I have a 2-hour collaborative meeting on this day, and then next month I'll have another 2-hour, or maybe you do more in the same month, depending on the case. But the reality of it is it's predictable. On this meeting we're going to try and settle this, and the next meeting we're going to try to settle this. There's a meeting to kind of get our bearings, and then there's a meeting to sign ultimately at the end. But it's much more predictable, and it's much less stressful. But honestly, that's not even a big enough word for the type of pressure litigation puts on families. And your kids are not immune to a litigation case by any means.
No, in the last month or two, Jeanna, in our litigation cases, both of us have had to bring children into court for really contentious child custody issues. And it can be really, really stressful. It's scary for them because it's just a very unknown, very formal, very official process. There's all these strangers. And then, of course, they've got their parents there, and they're having to navigate, speaking their mind with a judge who's also a stranger, their parents' attorneys who are also strangers. Hopefully, your children are not meeting your family law attorneys. Just in a routine scheme of things. But it's a lot of emotional turmoil for them. It's also really hard for the parents to watch their child have to go through that. It's kind of every parent's like last resort, and unfortunately, sometimes it's just what you have to do in a litigation case. But I think one of the things that I like the most about collaborative is it is self-scheduling. So for some families, it could be that they've just separated, and the separation could be something really traumatic happened that caused the separation. an infidelity or something like that, where there's a lot of feelings. And that may be a collaborative case where they need more time in between sessions to process things, to figure out how they're going to deal with certain issues. They can kind of pick the order of things because there's some things that infidelity is just not going to matter for. Yeah. A court's never going to consider that really in child custody unless it affects the kids in some way, and it usually doesn't. So that might be a safer place to start, and you leave some of those other issues till later. At the same token, some families, they're very collaborative and speed is their priority, and you can have a short amount of time in between sessions. It's all dictated by the parties. And one of the things that we get a lot is like, well, it's collaborative. Does that mean, like, obviously, if we were 100% collaborative, we wouldn't be going through a divorce. So what does that mean? And I always tell clients, collaborative isn't meant to describe, like when we say the word collaborative law, we're not trying to describe your relationship with your co-parent, with your ex-spouse. What it is the process through which the attorneys engage in sharing information, all of those things. That is a collaborative process. The problem solving is a collaborative process. So when you enter into a collaborative case, you sign a pledge where you agree to confidentiality, but you also agree to the free flow and free sharing of information that's pertinent to the case. So that means all of your financial information for both of you is being shared, information about the children. You're not withholding anything. You pledge to be completely truthful about the things that are relevant to your case. And that can be scary and daunting for people, but it also is part of that collaboration. And that's how we as attorneys are able to sit down with our clients in a collaborative session and do the work, because we've shared that information and the attorneys are demonstrating what that collaboration looks like. Yeah. And sometimes that does mean that the parties themselves kind of come around to a more collaborative frame of mind because they're seeing that modeled for them. Yeah.
So let's kind of talk about attorney fees in collaborative versus litigation. A lot of people, certainly the majority in my experience, have never hired a lawyer before, except maybe for a traffic ticket. Yeah. But family lawyers, for the most part, and obviously we're only speaking to what we know, but most family lawyers bill by the hour. We're hourly, which means you're going to be charged for every time we touch your case. With collaborative, again, it's more predictable. So a big thing that Emily talked about was the free, share of information. That's something in litigation that you may have to fight to get through discovery, motions to compel, things like that, to literally force and use court resources to get that information. And we're skipping that in collaborative. So that's already in and of itself a time saver. We talked about the delay in litigation. So that's something that a lot of times we just can't control. And the longer it goes on, the more times we have to touch your case, the more you're going to be charged. So, it's more predictable, and we find that clients are much happier with their experience working with an attorney, dealing with a divorce, when the fees are more predictable and they just are in collaborative. That's why it's cheaper. It's not that, it's easier. It's not anything like that. It's just literally the time spent is less, and also we can predict it. Like at the outset, if someone comes in and wants to hire me on a very contentious litigation, I'll tell them, well, it's this amount to start, but expect it will go up and up and up. Like, we just don't know. In collaborative, we still can't obviously identify exactly the dollar amount it's going to be, but we can say, look, you're going to have this many meetings. Like, it's just more predictable. It's just, easier to predict.
Yeah, that's true. And that brings up a good point for, I guess, like in North Carolina, the litigation system, because when you have a child custody case or you have a financial case in North Carolina, you're going to be mandated by the court, unless like there's domestic violence or some barrier, you're going to be mandated by the court to participate in mediation. Mm-hmm. With child custody, that's a free program in North Carolina with a court-appointed mediator. With most financial cases, that's going to be a private mediator who you're going to end up paying. So you're paying in those sessions for your lawyer's time and also for your mediator's time. You're usually splitting that between the parties. Not always, but often. So the thing that's different about collaborative versus these mediations, and I know Jeanna and I have both been parties to these, mediation sessions can take hours. 12 hours is not an insane amount of time to spend at a mediation. And it's all at once. And that can kind of sound like, great, I'll have it all done. But what it oftentimes comes to, and a lot of attorneys talk about this, is you end up with a lot of last minute agreements at 6 or 7 p.m. because everybody's been there since 9 and they're tired and they want supper and they want to be done and want to go home and they want to go watch TV and they want to, like, go on with their life. So they'll agree to things, and they'll agree to things that are binding, and they'll often sign things that are binding. And then afterwards, there can sometimes be like a buyer's remorse that happens in those, especially if they perceive like they got the wrong end of the stick. They got the worst end of the deal for whatever reason. And one of the things I like most about collaborative in that space and how it's different is that we do things over a series of sessions. Usually at least 4. It can be more than that. Really, it's as many sessions as the parties feel like A, they need to get to a resolution, and 2, up until the point somebody says, okay, maybe this isn't working for us. Collaboration necessitates everybody being able to come to the table. But those sessions are usually 2 or 3 hours long, tops. That's it. And so you don't agree to anything that day and sign something that day. Usually you're talking about it, you're thinking it over. You have like a week, 2 weeks, however long in between your sessions to think about that. And if you think about, like, well, we didn't really think about Christmas, or we didn't think about this particular aspect of our financial life or whatever, it's always up for revisiting and renegotiation. So it's not this marathon pressure cooker kind of thing. Instead, it's this pretty metered, measured way. So that way, when you come to the point you are signing documents, nothing in that document should be shocking, a surprise, an 11th hour addition. It should all be ironed out and thought through.
And we're kind of talking about all the types of benefits. I mean, there's so many. Something else I really want to talk about as a benefit is when you're in litigation, you are not just bound by the rules of civil procedure. Those are procedural rules, but also the rules of evidence. And this isn't to be, I'm not going to make this a evidence lecture like in law school, but a lot of people know what hearsay is. And hearsay is obviously a very real issue in custody cases, especially when you're talking about what the child says and the child's not there to testify about what they said or didn't say. And in collaborative, we have the ability to use that type of evidence in a way that we would not be able to in court. So I mentioned hearsay. Something else though, therapists. Therapists do not want to testify ever, almost. Like they will with the subpoena, but it can oftentimes destroy the therapeutic relationship that person has with the child, or one of the parents. Normally we're talking about the child though, because that's a person that has really deep insight into what the child may want or feel or whatever. That therapist can come to a collaborative session. An accountant can come to a collaborative session. Your financial advisor can come. A realtor can come. Yeah. I mean, literally anyone can come and weigh their professional opinion about something that would otherwise be a little bit more difficult to get in court. I mean, obviously a lot of these things could certainly come in court as testimony, but it's much easier and lower stakes to have it done this way.
Yeah, and a lot of the time with those experts, you're agreeing to who you want as an expert. So, like, if you have a house and you're trying to get an appraisal done to figure out what the value of the house is, because the housing market is cuckoo bananas, you and your spouse can agree to an appraiser that's neutral, that's going to be the person that appraises the value of the house, and that's it. So you don't end up in these kind of like war of the experts kind of scenarios where I've got a certain appraisal, Gina's got another appraisal, and now we're going to go into court. We're going to fight it out and figure out whose appraisal it is. FYI, most of the time judges just kind of split the baby on that. So you end up with a number nobody wanted. So it allows you to kind of pick who those people are together as a team and, figure that out in a way that feels much less contentious and ultimately means less costs for the family. Because one of the things I tell people, if they have property, they have bank accounts, they have that sort of thing, you are ultimately in a litigation case pulling money out of the family estate most of the time to fight about the family estate. So you are diminishing the value of the family estate while you fight about it, a lot of the time. And it's happened more than once that I've seen a case that maybe might have had some positive financial value, but by the time litigation is done and the dust is settled, there's no positive value left in the estate. And then you're stuck in really, really tough situations where you're figuring out whether you're going to sell a home that neither of you really anticipated having to sell, having to let go of other property you weren't anticipating because the financial cost of litigation are just so extreme sometimes. Yeah.
Something else that we get asked often is, why would I agree not to litigate? I hate this person. Or, maybe not hate all the time, but a lot of times hate. A lot of times hate.
Yeah.
I hate them. I want to bring them into court. I want to tell everything. Well, there's a couple of reasons why you might want to think twice about that. We talked about the costs, all that, but let's talk about the family dynamic. Let's talk about if you have kids, okay? Two big things. The first thing is the fact that you are going to sling mug. You're going to sling mud all around the courtroom about your ex, who is the father or mother of your child, who you have to co-parent with. I mean, there are instances where one parent is completely unfit or whatever. We're talking about the average, and that's the case is probably not good for collaborative anyway. But we're talking about the average family where you have two decent parents. Just the average divorce is what we're talking about. So you're going to go into court and you're going to say everything bad about your ex, okay? That's on a court record that anyone can pull and listen to later. The order that the judge signs that comes out of that is going to have a list, what's called findings of fact, and it's going to be in there for anyone to pull, especially now if you're in e-courts jurisdiction. You can pull it up online, and your kids later can also pull that up. Okay, so we have public record of everything. You're going to leave that courtroom. Say you get what you want. Say you don't, it doesn't matter, but say you get what you want. You leave that courtroom, you're so excited. Oh my gosh, like I got the custody I wanted or whatever. Okay. The relationship that you have to co-parent has just totally been, just totally blew up. And that impacts your child. I mean, it just does, because 9 times out of 10, you're going to have to co-parent to some capacity, and your child or children are going to see that. The second thing that I want to mention about, this question of why would I agree not to litigate is also goes with the financial aspects. If you were going to litigate the finances of your case, the judge that you go in front of has no idea about you, about your child or children, about your bank accounts, about your retirement accounts. They have no idea about the financial picture. It's up to your attorneys to show them the financial picture of your case or show them what, the relevant facts are for custody. But at the end of the day, no matter how, experts these judges are on these cases, they don't know your case. Would you, in any other circumstance, give a third person the right to decide how your finances are going to be? I mean, would you go up to the cashier at Target and say, hey man, so I have a house, I have this, you decide whether me or my wife or me and my husband are going to get what? No, you wouldn't. And yes, a judge is obviously very smart, obviously on the bench for a reason, but they don't know. They're still a third party. When you litigate, you're giving up control of what happens to your finances, what happens to your kids. And this by no means is to say litigation has its place. Sometimes it's the only option. Sometimes it really is. But what we're here to talk about is it doesn't have to be that way for a lot of people. So just consider that. Would you bring your finances to the Target cashier? No, you wouldn't.
Yeah. And on top of that, to kind of combine those two thoughts together, your financial information is also going to be out there, because in your property distribution case, in your alimony case, whatever, judge still has to make findings of fact. So your income, what you make every single month and how you make it, let alone any kind of bad factor, because in alimony, things like infidelity play a huge role. So all of that's going to be out there for sure. And in your property distribution, I mean, they're going to know your entire finance. For most people, unless you had significant assets before you came into the marriage that aren't part of the marital estate, for most folks who've been married for a long time, for me, for example, I've been married for 11 years. Whew, had to think about it. So for me, like my entire financial life would be out there. Everyone would know exactly how much I make, what my house is worth, what my puppy dog is worth, what I've got in retirement or don't have in retirement. Heyo. What I've got. They would know every single thing about me. And for some people, especially folks that are in public facing professions, like lawyers aren't immune to going through divorce. Judges aren't immune to going through divorce. College professors, therapists, doctors. There's no level of education that you're going to get that's going to educate yourself out of a divorce. There's no amount of public officials, mayors, delegates, all sorts of people go through divorces. And a lot of those people don't want that information out there for the public to consume, because they're Googleable. And then now your financial life is Googleable. And now there's a newspaper article about everything that's going on in your life. And that's not pleasant. So one of the things we've talked about cost. We've talked about the free flow of information. Another aspect that we're kind of circling around is privacy and confidentiality. Oftentimes, when you do a collaborative case, nothing gets filed in court other than your divorce decree at the end, because you have to get divorced. You have to get literally divorced, unmarried from each other, through a court order. But that's very generic. It's like a 2-page complaint. It says just the bare bones of when you were married, when you separated, whether you've got kids, that kind of thing, where you live, that sort of thing. But everything else is in a private contract between the two of you. So that information, while it's shared in between the spouses and their attorneys, that is free flow. In terms of how it gets shared with anyone else, it's completely locked down. And a part of that is when you sign that pledge that we talked about. When you sign a collaborative pledge, you are agreeing that if you've disclosed all this information, you've been open, you've been honest, you've told everything, you've given everything, maybe you've hired experts for the thing, unless you agree to something different, that information doesn't just, if you decide it doesn't work, collaborative fails, and that you need to file a lawsuit instead, that information doesn't just get released into litigation. You don't get to bring your attorney from collaborative into your litigation case if you choose to do it. You don't get to bring that financial information or all of the things that have been shared in those collaborative sessions directly into litigation. So there are some safeguards there, even if the process doesn't end up working for you, to keep some of that information private, unless your new attorney, because you'll have to have a new one, your new attorney decides to do that through discovery.
That actually segues really nicely into kind of the logistics of collaborative. So Emily mentioned the pledge. You both have to agree to participate in this process. It can't be one-sided. And that does, that turns out to be the hang up in a lot of these cases, is one person doesn't agree to the collaborative process. So you both do have to agree. You both have to sign a pledge. And that kind of begs the question, like, how do I bring this up to them? So, in your area, specifically in Guilford County, we do have a practice group. The attorneys in that practice group will provide a flyer to a potential client to give to their spouse with other attorneys that they can hire. And there's also resources online about collaborative law, especially in divorce. But I would recommend that, reach out to your spouse, soon-to-be ex-spouse, about it in the way that you want the collaborative process to be. So going to them and explaining, look, here we are. we are here. We are separated. And obviously, we have a home, we have kids, we have things we need to figure out. I feel like this process will be so much better for everyone if we do it this way. But here are some attorneys that you can go have a consult with about it and leave it at that. And something else to mention in collaborative of note that Emily kind of mentioned in her spiel is that you cannot use the attorney that you use for your collaborative law divorce in a future litigation about that divorce. So there is an incentive to settle. I mean, there's a million incentives to settle, but that's a big one because you're going to incur additional attorney's fees. You're going to have to get a new lawyer and you're going to have to start all over again. So, all things to think about. Cases with domestic violence, with any sort of safety concern, no, those are not the greatest for collaborative. Actually, they're no. That's the reason why I have litigation. But I think the message here today is if you are about to be separated or if you are separated and you are really concerned about the future of your financial life, of your children's life, and you just want to move on. You want to turn the page. You want to start a new chapter. Collaborative is something really to consider.
Yeah, kind of as my final thought, I'll tell people there are two things with litigation that I think you need to bear in mind. One, and when you're thinking about litigation versus settling, and I have this conversation all the time. One, if you go to litigation, which is a big if you do end up going to litigation, you are putting the most valuable pieces of your life in someone's hands who 2 hours ago, a day ago, did not know you. And oftentimes, because family law courts are courts of equity, where we're looking at fairness and we're weighing what's equitable between the parties, oftentimes what happens is that neither party gets the result that they wanted. It ends up being something in the middle for a lot of people. And neither side is satisfied when they walk out, let alone the emotional turmoil, all of that. The other thing I'll tell you is, I said that as a caveat for a reason. I would say maybe about 50% of cases go to litigation. 90% of those cases end up settling anyway, because you get to the point where somebody has lowered those emotions. They have started thinking of it as a financial picture, and litigation from a financial aspect hardly ever makes sense. So we end up with a settlement, or someone doesn't want to go in front of a judge because they realize that it's crazy and chaotic, or frankly, sometimes people run out of steam, they run out of gas, they run out of, resources, either mental, emotional resources, time resources, financial resources, and they feel like they have to come to the table to settle. So oftentimes what you're doing by engaging in an alternative dispute resolution process, mediation, collaboration, something like that, ultimately what you're doing is cutting around a 18-month long litigation that you're going to end up settling anyway on the courthouse steps. So in my mind, it really cuts out a lot of complication without really changing what my outcome ends up being from an attorney's perspective in the case. Yeah.
Not to mention, these settlements that happen in litigation cases often are 11th hour settlements right before the trial starts. And that goes back to what we were talking about with those long mediations. Like, are you really making the best decision in that moment? It's just something to consider. But it's true, even litigation cases, almost all of them statistically settle. So all that to say, if you are in the Triad area, so Greensboro, High Point, Winston-Salem, even out towards Alamance County, Camino Law would love to help you through your case in a collaborative manner. You can find us at our website. You can find us on Instagram, TikTok. We love TikTok. But please reach out if we can help you.
And last, just as a shout out, we're also members of the Triad Collaborative Law Group. We have a website. You can Google us. That is not a law practice group. Jeanna and I are we practice together at Camino. So we work in the same law firm, but this is a group of different attorneys from different law firms who all practice collaborative law together. So we have cases together often, but we are independent attorneys from independent law firms. Check out our website. There's a lot of good information just generally about who the practitioners are, but also about the collaborative process, trying to answer questions, resources, that sort of thing. So check us out.
All
All right.
right.
Bye.
Bye.